For those of you who don't know me, my name is Professor David Wilkins. I've been on the law school faculty for 31 years, which means most of you probably at least were around when I was around, although I think there may be a few students here whose class date predates mine. But I am, among other things, the faculty director of the Center on the Legal Profession. And one of the things we try to do at the Center on the Legal Profession is to think about legal education and how it's changing not just here in the United States and around the world. I'm also the co-founder of Harvard Law School Executive Education, in which we try to think about what education means not just for law students, but what education means for professionals. And I also have the title of Vice Dean for Global Initiatives on the Legal Profession, which sounds really, really important, except it comes with no money and no staff. But other than that, it's a great honor. But in that capacity, I try to think about how all of these things are changing around the world and how they ought to change in response to the changes in legal practice, and how legal education might seek to shape legal practice moving forward. So we have an amazing panel here to discuss these issues, who I'm going to introduce in a second and try to get them to say a few words about what they think about these issues. But we also have an amazing audience here, which includes several faculty members, including our own Professor Terry Fisher from this very law school, but also from other law schools around the world, as well as law students, both here and around the world, who have as great or greater knowledge about what the changes are and what they think about what should happen moving forward. So I promise you that we will try to make this an interactive dialogue, not just among the people on the panel, but also with all of you. Let me just say a few words at the beginning about kind of what, from my various vantage points in the terms of the work that I do, that I have been seeing. And maybe that's a way of kind of setting the context that I'll hopefully get our terrific panelists here to react to and then engage all of you. So I started my career here back in 1986, studying the legal profession as kind of the principal thing that I do. And the moment I came here is really the moment that the legal profession really started to change quite dramatically. First here in the United States, but increasingly around the world. And you know, we could say a lot about what those changes are. I try to put them in 5 different buckets. We've seen law go from primarily a profession of solo or small firm practitioners. So even in the 1980s, I graduated from law school in 1980, and something like 70% of all lawyers in the United States were solo or very small firm practitioners, and that was even more true around the world. Now law is increasingly practiced in organizations of greater and greater size. It doesn't mean that there aren't still a large number of solo and small firm practitioners, but we've seen more and more lawyers practice in some kind of an institutional or organized setting, and that organizational setting is of increasing scale. So when I was a law student, a big law firm might have 200 lawyers. That was considered gigantic. You know, now that's the Dayton branch of Akron law firm. And that we have law firms in the United States of something like, 3,000. And that's not just for law firms. Government law offices, NGOs, public interest organizations, lawyers who work inside big companies. We just had a panel here on general counsels, which are of increasing importance and increasing scale. And this is happening all over the world. Second, law has gone from an incredibly homogeneous profession to one of increasing diversity, although, as many of our panelists might say, not as diverse as perhaps it should be. But, you know, law basically was a career for men of a certain class and social and religious background. And that was true not just, again, in the United States, but around the world. If we look around the world today, law is becoming an increasingly what the sociologists would call feminized profession, which simply just means that the majority of entrants here in the United States, it's a little over 50%. In most places in the world, it's way more than that, 60%, 70%, maybe Raj will tell me in India, of the entrants are women. And yet, the career path in law in almost every part of the world is not just made for a man, it's made for a man who has a wife who doesn't work. And how many of those are there? And that's just one aspect of diversity. We could talk about racial diversity. We could talk about ethnic diversity. We could talk about gays and lesbians in the profession. We could talk about religious diversity, which is a huge issue in many places around the world. You know, so a huge change in the people who are lawyers. Third, law has gone from a kind of artisanal craft, you know, governed by professional norms, to an increasingly large and global business. Now, that doesn't mean it's not still a profession, but it is very much more of a commercial enterprise in which people have to think about the realities of the marketplace, much more even than when I was there. And that is changing even more rapidly as we move forward. We can also think about the competition for who provides legal services. So it used to be all about lawyers. But in fact, much of what we think about law and legal practice and legal services, as we will hear from John Suh most dramatically, are not being delivered just by lawyers. That technology, that other professionals are playing a greater and greater role in the way in which we think about what legal services are. And finally, law has gone from the most local of professions, in which, you know, you didn't just practice law in a country, you practiced law in a jurisdiction, perhaps even only a city, and your clients were also in that same jurisdiction, and you met them face to face. It was a personal service, to one that is increasingly not just global, but remote, by way of technology, by way of the increasing expanse of organizations. And yet, there is no such thing as the global legal profession per se, or global law, or even, notwithstanding the fact that I'm speaking to all of you in English, a global language. And that we know that culture and history and language and proximity still matter. So we're in this complex world, which sometimes, borrowing a phrase from my friend Carol Silver, who teaches at Northwestern, I call glocal, which is just global and local all smushed together, okay? That's the complex world of legal practice that we live in, and quite frankly, it's gotten even more complex after 2008, after the global financial crisis. In which all of the trends that I talked about have been accelerated and pushed along even faster in the years since the financial crisis, to the point where people are asking, are we at a kind of paradigm shift? I can't tell you how many conferences I've been to which have the charming title of things like the death of big law. For those of you who are in law firms, they're talking about you. Or my friend Richard Susskind wrote a book several years ago which has the charming title of The End of Lawyers. He always reminds me there's a question mark at the end, so maybe there's hope for those of you who are still law students and wondering if you should quit immediately. So is it a paradigm shift, or is it really a moment in which what we ought to do is to go back to our traditions, and the fact of the matter is the world will follow us? Here's my very fancy Harvard law professor answer. Who knows? At least I don't know yet. But I'm pretty sure of this. It's going to be some combination of both, meaning that there is going to continue to be important and quite substantial change in the way in which lawyers practice law. But it's also true that many of the core ideas about being a lawyer, about loyalty to clients, about connection between law and public service, about the importance of the rule of law to democracy, those things not only won't change, I hope, but shouldn't change. And so again, we have to think about how to manage continuity and change. If all of this is going on in the world we're trying to prepare our students for, what are the implications for legal education? After all, in almost every country in the world, and every country in the world as a formal matter, as a de facto matter, even if not a formal matter, legal education of some kind is the gateway to the profession of law, even if it isn't now any longer the exclusive gateway to people who work on areas that we would call legal areas, or who engage in work that we would probably have in some other time called legal work, or perhaps still call legal work. But that makes legal education critical, because it is the place in which we can begin to train the next generation of lawyers for the challenges that they face. But legal education does more than train students. Legal education also, or law schools also, are an incredibly important source of knowledge about law, legal institutions, the rule of law, and the relationship between law and society. Law schools and law professors, whether they are in postgraduate law schools, such as here in the United States, or undergraduate law schools in many other parts of the world, are incredibly important at trying to help educate not just lawyers, but society as a whole about law, legal issues, and hopefully legal practice. But there's more than that, because law schools are also a place not just where students learn legal skills or legal rules, but it's also an incredibly important part of professional socialization about what it means to be a lawyer, and what are the broader public responsibilities as well as private responsibilities of lawyers. In other words, law schools have many, many tasks, and they have always had that, but now they face those tasks in a world that is itself changing dramatically. At the Center on the Legal Profession, we've been trying to study these changes, both in the United States and around the world. One of the ways in which we do so, because we're such a global audience here, is we run a global research project which we call Globalization Lawyers in Emerging Economies, or GLEE, as we like to call it, after the popular TV show. Some of you will have gotten the joke. I don't wear a tracksuit and I don't sing, but I do study how is globalization reshaping the market for legal services. And one of the key aspects is legal education. We've just published a large volume on India. We're about to publish one on Brazil. Another one is coming on China. And with Ruth Okediji here, we want to say that the next place we're going with Ruth's help is Africa, to understand how these issues are unfolding around the world. So that's a little context about thinking about why legal education is so critical, but also why it's at such a critical crossroads. And we are very fortunate today because we have an incredible panel of 5 distinguished people, all of whom have had some connection with this set of issues, who have helped to shape where we are today, not just in the United States, but around the world, and who are the kind of people who can help us to understand how these issues should change and evolve over the coming years. I'm just going to give them the briefest of one-line introductions, just because you have their bios and we don't want to take time in introductions. We want to take time in discussion. So on your right, I guess that's my right if I turn around like this, there's Bill Lee, who's the former managing partner of WilmerHale, also someone who has taught here in the law school faculty for many years, and roughly speaking is the boss of everyone at Harvard because he's the chair of the Harvard Corporation. Next to him is John Suh, who is the CEO of LegalZoom, which I will just say, John, you should know is the most recognized legal brand in the world today. The most recognized legal brand is LegalZoom, and as he will tell you, it's not a law firm. It's something different. Next to him is Michele DeStefano, who I've known since she was a student here. I'm very proud of Michele, who's now a professor at the University of Miami Law School and who runs the single, I think, most innovative program in legal education called Law Without Walls, and I hope she'll say a little bit about that later on. Next to her is Ruth Okediji, who is our newest, or one of our newest colleagues here, who we just swiped away from the University of Minnesota, and who is the leading expert on intellectual property, particularly in the developing world, particularly in Africa, but who has thought deeply about how to train the next generation of lawyers. And then next to her is C. Raj Kumar, who is as close to a kind of founding father of legal education as I think you're ever going to meet. Raj is the vice chancellor and founder of the Jindal Global University in India, a university which he came to talk to me about in 1999, saying, oh, I have some ideas, and maybe I've gotten $100 million. I said, rupees? He said, no, dollars, to start a new university from the ground up. And I said, well, first you have a committee, and you take 5 years, and then you study a site plan, and you take 5 more years, and then you have a curriculum committee. He said, no, we're going to be open in a year. And they were open in a year, and they've become one of the most important universities, not just in India, but the world. So you can see we have an amazing panel. Let's get right to it. I told Bill Lee I would pick on him first, because he is the boss, after all, and because he has this really unique position of having presided over one of the most important law firms in the United States during an incredible time of transition certainly between the time you joined Bill and the time you stepped down as managing partner, although he's far from retired, as you will see. But he's also been intimately involved in helping us at Harvard Law School think about legal education. So Bill, and he also wrote a paper with me and Ben Heineman on some of these issues. So Bill, can you talk a little bit about how you see the changing role of the lawyer and its implications for legal education?
Sure, happy to do so. And I may do it a little bit from a historical perspective and also give you a couple vignettes that will illustrate it. And I think, hopefully, my domestic vignettes will actually make everything that everybody else in the panel has to say even more relevant, because in some sense what they're doing is even more relevant than what I've done over the last 45 years. I have had the great honor and privilege of not only writing this paper with David and Ben, but also working with David to help design a course called the Problem Solving Workshop, which was new 9 years ago now. David and I have taught it together for 9 years. But it was basically to address a concept that David and Ben and I articulated in the paper, which is the multiple roles of lawyers. And it describes 3 roles that are important today. One is analytical thinker, one is wise counselor, and the other is leader and team player. And they're different than certainly when I went to law school. I graduated in 1976, so I'm even more advanced than David in age. Being a superior analytical thinker was enough. Right? It really was enough to get you a great clerkship or a great job or start moving you through your career. It is no longer enough. And why did we come to this conclusion? And this is where I'll give you a couple vignettes. When I started in 1976, I ended up working on the largest litigation the firm had ever tried with Jim St. Clair, who had just come back from representing President Nixon. It was a 4-month jury trial that went to the First Circuit of the Supreme Court, where a group of Indians claimed an entire town on Cape Cod, about $1 billion in property when $1 billion was real money. That whole case had a team of 3 people, right? It lasted 4 months, but that team of 3 people could deal with the complexities of the case, the exhibits in the case, the law in the case. That was enough. Fast forward now about 4 years, I represented Apple in the worldwide war with Samsung. And while the U.S. cases got the most of the press, the main event actually was outside the United States. There were 59 cases in 17 jurisdictions where the iPhone and the Samsung Galaxy were litigated on different legal regimes, different principles, different procedures. It was the same product, it was the same facts, but the implications in each market was different. And you think about how different that is from the case that I started with. We had to sit back and say, how do you deal with this? And here's what we did. It's become partially public, but we actually brought everybody together from the 17 different countries, 18 including the United States. And on the first day, we had a mock trial before a United States jury of the same case. It scared the hell out of a lot of people from other jurisdictions, right? And then the next day, we went around the room and asked everybody from the other 17 jurisdictions, who would resolve this case in your jurisdiction? How would it be resolved? How quickly would it be resolved? And what would the result be? And the answers were different in each of the different jurisdictions. Some of them radically different, some of them not so different. And it helped us ultimately devise a global strategy to decide where we wanted to be, where we didn't want to be, how fast we would go. But the bringing all these folks together who had different legal regimes, different legal procedures, different cultural imperatives, right, was something that we never had to do when I did law school. And it requires a different set of skills than I certainly learned when I was in law school, and a different type of education. It requires you to think more broadly, differently, to have more peripheral vision than you might have otherwise. And at the end of the day, the strategy we put in place ended up working out very well in the 59 litigations that we had to do over 5 years. But that's how different the task is from when David and I started. And the premise of the paper that Ben and David and I wrote is because the task is so different, what you need in a lawyer is a different set of characteristics, and therefore the education of that lawyer has to be different. Now, just let me end on one thing. There are so many things that have changed in what a lawyer should be. I think one of the things we also teach in the course is there are things that haven't changed, as David said. There are certain things that are just predicate for the profession. And on the last day of the class, David and mine are very close to the same. I try to focus on one of those, and that's the integrity of the lawyer. And for the last 3 years, I brought Bob Mueller in to talk about it, but I don't have him available to me anymore. It's going to be have someone different, but there's a little vignette that I think captures this integrity aspect and why it's still one of the key aspects of being a lawyer, even in the global environment. And it comes from Justice Souter, who used to tell young lawyers the following. He said, if you want to be a great lawyer, you need to do 3 things. You need to be prepared, you need to be yourself, and you need to be a decent person of integrity. And then he would pause and say, now if you can only be one, be a decent person of integrity. Right? And that is the same. So there are many things that are different, and the course that I've worked on with David is to focus on the different things that a lawyer must do and how we educate the lawyers to do those things, to confront these different types of problems and the different types of imperatives and issues. But there are some things that are the same for the profession, and we can't lose sight of those things as well.
Thank you, Bill. John, you know, you have a unique vantage point because not only is LegalZoom not a law firm, you're not a lawyer. And you have actually thought about these issues from an incredibly important and fresh perspective. And LegalZoom, in many ways, has concentrated on the other part of the legal profession that isn't the part Bill has talked about. That is not the part of the, you know, the large law firms and huge litigation that spans the globe, but that other critical part of the legal profession, which we should never forget about, which is service to individuals or small businesses. And I wonder from your vantage point, both how you saw the world evolving and why you decided to take your Harvard Business School degree and your substantial knowledge of technology and of organization to think about creating a new kind of organization in the world of the ordinary person.
So it's somewhat ironic that I'm here, because while I'm not a lawyer, I was a stowaway at Harvard Law School when I was an undergrad. I found a way to finagle myself into Roger Fisher's class on negotiation theory. I did have to work for him at conflict management to get through and do a special concentration. But I had I was always fascinated by systemic solutions to systemic problems. And I thought about the Kennedy School and public policy, and was my MPP, MBA, and the like. But I think one of the things we do is we try to shine a light on the middle. I think it's very easy to focus on kind of the bright lights of the AmLaw 100 in the corporate world and their in-house equivalents of GCs. Or even, I think, on those that create and shape the law, whether they're members of the judiciary or the legislative body or academia. And then I think the law does a lot around that area that's very important. And the legal education is highly focused on thinking and the application of, and really training to think through those particular issues. And then I think on the other side, there is, I think, very important attention to the critical work of those focused on the 15% of Americans below the poverty line that are frozen out of the legal system. What we see, though, is when you say access to justice, people naturally turn to the 15% of people below the poverty line. And what we look at is the folks in the middle. It's like, who is now serving, who is providing access to justice for your friends, your family, for your favorite restaurant on the corner? Because what we've seen is a 40-year trend where we've doubled the density of lawyers in the US on a per capita basis, and yet increasing the cost of legal services escalated out of reach of the average American. We think about the 84% of folks in between the top 1% and the bottom 15%, and really 99% of small business. And so we shine a light on that particular problem. And that's serviced by, largely by solo practitioner boutique law firms. Boutique was actually a healthy practice on a relative level, but solo practitioners, according to the IRS, 350,000 solos, 113,000 in revenue, and experiencing a 40% decline in take-home, and are now at 49,000 of take-home income on average. So 15 years into your solo practitioner career, on average, the top 10% actually reasonably healthy, but on average, it's devastatingly bad. You're making $4,000 more than the average college grad, but with quite a bit more debt. And so what we see in kind of shining a light on that problem is we have a systemic problem that's getting worse the last 4 years, and no one's really addressing that particular issue. And it's a problem of unutilized capacity. Clio did a great study on solo practitioners, and we're actually 9 out of 10 hours at an AmLaw 100 firm are actually billed to a client and then collected. So time is the money, so the bill of hours is a great construct for that. We found that solo practitioners, on average, charge $232 in 2016, or about 46% of the billable hourly rate. But they take home about 3% of the profits of an average partner. So it's just massive unutilized. They bill 2.2 hours per day. They work that on billable hours. They only charge a client 1.8. And they only collect 1.5. So there's leakage across the system, 70% unutilized capacity. So there's something totally broken. You have 70% unutilized capacity of people that can help. And you have people frozen out that are just looking. So nothing is matching here. And what we've done, I love the term global, because we file in every courthouse in 3,000 counties, and every day we walk into every Secretary of State in the USPTO in the U.S., and we work with 30 boutique law firms in the U.S. But actually, oddly enough, in the U.K., we are a law firm. We purchased a law firm based on the Legal Services Act in the U.K. that opened up in February of 2016, and now we have over 200 professionals in our ABS, the Alternative Business Structure. So it's weird. We had to change the advertising. We couldn't say we're not a law firm anymore because we actually are. We just have to qualify UK versus US. So when I think about legal education, I think of it in three ways. One, there's so much attention on both sides. What percentage of the curriculum or the focus of the content? And here there's actually quite a bit on kind of the practice, on innovation, and what's happening to the everyday. But thought leadership is critical. Data is critical. There's a paucity of data around what the average American small business owner faces today is the engine of job growth. And if we all believe that access to justice is a fundamental right, without which democracy and capitalism don't function as intended, this 40-year decline, someone's got to create a solution. So I think there's a lot of great work on thought leadership and the like, but I think part of that is clinical practice, so that thought leadership is married with face-to-face exposure. Because I think if you stay in the ivory tower without kind of that face-to-face, nothing actually works. I think a critical part of the curriculum that I see, and I speak probably to maybe 5 to 10 state bars each year, or the ABA or what have you, and we're all in these panels. And I talk about this hero worship. The same in private equity. Private equity looks for the CEO often, and like we're one of, as opposed to my entire team. And lawyers often it's this hero worship of one. I remember I was talking about how do you employ technology, and one of the state bar conventions said, well, how should I learn how to code? I was like, I've been in the internet for 22 years and I don't code. It's not about you doing it. It's about how do you, with your leadership, with your core skills, function as a team. A systemic problem will require, diversity was a huge part of the earlier panel. The diversity of skills, diversity of people. You need a systemic team, really a team to create a systemic solution to a systemic problem. And that's a diversity of skills. And is that what is being taught in law school? Is that being taught amongst our future leaders? And this cult of one, which I see in kind of the world that I deal with on the financing side, or in the legal, it's inappropriate for fashioning these types of solutions. And so I think part of it, even in the law school curriculum, is the way that you could reach out to other folks, whether it's at the business school or at the Kennedy School, or an MIT Media Lab right here. Those types of partnerships will start to yield very different solutions because of the application of technology to law that I don't see it as dramatic in the next 3 years, but I think it cataclysmic in the next 5. So it's right around the corner.
That's fascinating, John. Michele, you're the perfect person to go next because you have actually tried to think very hard about what is the bridge between legal education and the kinds of problems that both Bill and John have talked about, meaning the explosion in the complexity and the size of some matters, or the widening gap between what ordinary people can afford and what they need even on a basic level, and how to think about it in a kind of interdisciplinary way that thinks seriously about technology but doesn't fall into the trap of thinking just technology is a panacea for everything, and you do it from the context of being in a law firm but doing so much more. So could you talk a little bit about what Law Without Walls is and how you think about kind of Law Without Walls positioning itself within these problems and the future of legal education?
Sure. So Law Without Walls is essentially the only learning and development program of its kind that tries to do 3 things. 1, train our future lawyers. 2, retrain our current lawyers. And 3, transform the way lawyers collaborate with their clients. So what we've all been talking about a lot is what type of lawyers do we need for the 21st century? And what Law Without Walls is designed to do is to train on a bunch of skills, not lawyering expertise. We still have tons of great law professors and great classes, Socratic method, things that have been working for years to address what Bill and David and Ben have talked about in terms of the analytics. But there's a whole slew of skills for the future lawyer that are needed that we don't actually teach in law school, and that current lawyers are at a loss for how to do. And those are at the base of what might be a pyramid, what I call cost skills: concrete, operational, service-oriented, and tech. And that's cultural competency, it's business acumen, it's learning how to mentor and give feedback, it's understanding legal ops, it's being better at communication. It's a ton of skills that we don't currently teach that are cost skills because they cost money to teach, they cost time, and we can't bill for them. We can't bill for training our associates on it or ourselves. Then higher up on the chain is what you might call creative, collaborative, problem-solving skills. And that's really around multidisciplinary teaming. And in order to have a team in the way that John is talking about is with empathy, growth-mindedness. Those attributes aren't usually focused on at law school. And then the last is innovation. What the DNA of the innovator, if you read Clayton Christensen and his co-author's book about what makes an innovator, those types of skills are really important. So in Law Without Walls, what we try to do is break down the walls and hierarchies that exist in law in order to train and retrain lawyers. And we put from 33 law and business schools from around the world, we create a team of 3 students, and we give them 2 team leaders, which are 2 junior partners from a law firm, and a topic expert, which is the client. And this is the core team that is assigned a challenge that's sponsored by a big corporate, like LegalZoom, which has sponsored a topic for many years in a row. But we also have Microsoft and Bupa and Spotify, Holland and Knight, Pinson Masons, Eversheds, Linklaters, the list I manage, the list goes on of corporations and law firms that get involved, and they give a topic that they really care about. And it could be a corporate social responsibility topic like Janders Dean sponsored around immigrants and refugees, or it could be something related to the corporation itself and communication, like between the marketing and the legal department. And this team goes on a 16-week journey together where they have to fine-tune the problem and then actually create a real solution, a prototype, a commercial, and branding, and then pitch it in at an ending event in front of a bunch of judges who will critique and help them refine their prototype. So why do we do this? We do this because it's the first time for many law school students and lawyers that are put on a multicultural, multidisciplinary, global team. Because in addition to that core team, we give them a legal startup entrepreneur, a marketing or business professional, as well as an academic who go on that journey with them. So over the course of the 16 weeks, they create an innovation in law. And in fact, for example, one of them is being brought to life with Allen & Overy's Fuse Incubator. We have a couple other projects also being brought to life. But the reason why we call them projects of worth is because along the way, those skills that you can't teach in a traditional classroom format, that you only can learn by actually doing. Look, you can't learn cultural competency. I tell my students every year I become a little less culturally incompetent each year. The only way you learn these skills is by working on these teams with technology every day, long distance, and making mistakes. And this is Law Without Walls is a really safe place. I think the one thing that drove me to try to create Law Without Walls was the lack of interaction between practice and education. And the beginnings of Law Without Walls was this idea of the people, the lawyers out there in the world, like many of you, bring back and give back to the law school students, and at the same time learn so much from those millennials. So maybe you don't need to learn how to code, but wow, you might learn how to make a new animation. You might learn some new skills and learn a lot about how the world is changing so that when you're meeting with your clients, you're up on things that the millennials care about and that are happening in the world. So that's pretty much it.
Well, that's a lot, as you can see, and it's why, again, I think it's one of the most exciting, innovative things in the world. But for the first 3 speakers, we've really been talking about our part of the world. We've been talking about how innovation and change has been happening to the legal profession, at least beginning in the United States, even though now it's the United States looking out around the world. But Raj, you had a very different challenge. India was a country where traditionally legal education was not valued. In fact, Raj often sometimes tells the joke about what he told his mother told her friends that Raj was studying at Harvard Law School, to the LL.M program to be a lawyer. And he said, what happened? We thought Raj was a good student. So, you know, starting from there, and starting from a place, Raj, where I've heard you speak many times very eloquently, where notwithstanding India's rich tradition and history, that it had not produced a great university that was focused on India's place in the world without forgetting India as an important place in and of itself in all of its complexity. And so you really have built a university, but maybe we could start with the law school from the ground up. And how have you thought about sort of doing so in the context where, as you were building it, the Indian legal profession was undergoing dramatic changes, as was the legal profession around the world?
Thank you, David. Well, the starting point was really about recognizing the presence and the place of India in the world. India has 1.4 billion people, and 850 million people in India are less than 35 years of age. Just grapple with those numbers, and you start thinking about the life expectancy of India, and it's around 72 years. So I believe that the future of India and the world are going to be shaped by many Indians, and that's why it's important for building a legal system and an institutional structure which will pave way for educating young Indians in relation to the kind of education that will prepare them for the future. With regard to the law school itself, I was hugely inspired by my experience of studying here at Harvard. And there are 3-4 things that shaped my thinking, and that was brought into the vision of the Jindal Global Law School. And first was the recognition that great institutions are built by outstanding individuals who can be brought into the framework of being faculty members. This was a historical challenge in India. The best and brightest of India for many, at least in the last several decades, don't choose academia as the option preferred career path. And this was the reason why most of Indian law schools, including universities, could never raise the academic standards and indeed contribute towards research. And so the first aspect of the vision of Jindal Global Law School was to be able to attract the best and the brightest of people from India and from around the world who are in a position to make a commitment towards legal academia. The second was something which was deeply embedded into the institutional vision, which is that the purpose of law and law schools is much broader than to be able to train people to become lawyers. In fact, the history and evolution of Indian legal profession from what was early phase, which was primarily to be litigating lawyers in the courts of law, has also transformed itself to an independent and autonomous discipline that looks at law and its contribution towards social, economic, and educational advancement of society, and including its need for building law as an instrument of social change. And that requires faculty members who are in a position to pursue research and indeed engage in writing. And that was the second aspect of the vision, which is to build a research-oriented law school. Third was in relation to recognizing that despite the global context in which we are functioning, we should recognize the importance of law being an instrument for pursuing the agenda of social engineering, and lawyers upholding the rule of law and contributing towards access to justice. In fact, as institutions and countries globalize more, the role of law in pursuing those fundamental values become even more significant. In fact, when many of us in the world witnessed the travel ban and how lawyers engaged in courts in India, we suddenly thought that lawyers must just change the world and save the world. And that's the kind of context-based lawyering which is important even in the context in which we are looking at globalization. And the fourth is a fundamental recognition of what David and the Center has been doing, which is to look at the impact of legal services in its broadest framework. To what extent law schools can prepare young law students to think about legal profession in a transnational manner. Gone are the days when lawyers can look at single jurisdiction-based training. In fact, we have dual degree programs in which Jindal students can obtain a law degree at Jindal, be qualified to practice in India, obtain a law degree from some of the US law schools in which we have collaborations, including Indiana and Arizona and Cornell, where they get a law degree here and they become multi-jurisdictionally trained. And now we have also collaborated with Australian law schools, which will enable our students to be able to practice in Australia. So in a way, recognizing the transnational nature of legal profession, responding to the globalization of services. In fact, law has been the last bastion to accept the framework of globalization. There has been huge resistance in many jurisdictions for opening up the legal sector. India still has not opened the legal sector, but I do believe that these changes are impacting the way lawyers in India are looking at. So I want to end by saying that the Jindal Global Law School's vision was to, in many ways, transform the legal education and in that process transform the legal profession in the world's largest democracy, and through that process impact many other countries in the world.
Thank you, Raj. It really is an exciting place for any of you who have an opportunity to travel to India. Raj is not only a fantastic host, but you will be incredibly impressed in the university that he's built, which is now just you opened it in 99 or 2099 was the beginning?
2009.
Not 99, 2009. So it's less than a decade old. It's really quite amazing. Ruth, you have been thinking about these issues from the perspective of a continent in which education is, kind of been used as a sword as well as a shield. Ruth has written passionately and persuasively about the ways in which kind of the rules about the way in which we train lawyers, not just here in what we might call the developed countries of the global north, but also in the developing countries in Africa and the global south, has actually been something that has reinforced some of the challenges that Africa faces moving forward in its own development. And at the same time, the basic kinds of access to knowledge, information about the changing global marketplace of the legal profession is often quite lacking in Africa. And I wonder how, from that perspective, you see these issues of the kind of changes in legal profession around the world and changing legal education from the perspective of Africa.
Thank you, David. I've been taking so many notes, and this is a great panel. Good morning, everyone. So those of you who've had me in class know that I love the law. I tell my students I would do this for free.
Don't tell the dean that.
Oh, I forget the bill. I forget the bill is here. Okay, let's erase that. Right? Don't record that. So I think that Africa, in terms of the legal profession, that there is a crisis brewing. We tend to think in the U.S. that we have too many lawyers, and I think hearing John speak, we actually see that it's not so much that we have too many lawyers, but there's actually a mismatch between those who need legal services and the capacity of lawyers to actually service them. And in the African continent, a number of things are I think, converging at a very alarming rate. Very similar to India, you have a large population under the age of 20. And many that are both not receiving proper education, but also then vulnerable to many of the global challenges that we are seeing around the world, including the recruitment violent groups. So this is a huge concern. And the legal services available, both for addressing the challenges raised by having such a large population, and the lack of basic institutions means the lawyers often are actually not being trained to deal with these gaps in the society. And that's a really, really significant problem. There's about 1.2 billion people in sub-Saharan Africa. All right, so not as large as India, but still a fairly significant population. Sub-Saharan Africa is producing about 10 to 12,000 lawyers a year for 1.2 billion people. Of that 12,000 or so, Nigeria is producing about 7,000. So one country producing the vast majority of lawyers available, and that's not enough to service that country itself, which has a significant population. So the underproduction of lawyers, the millennial generation, and globalization have become a three-legged stool, compounding the problems of legal services, because not only do you have a really high demand, you don't have the kind of training. So look at law school curriculums, for the most part, have not changed in the last decade. Now, what we have seen is the rise of clinics. And this notion that preparing, and I love what Michele is doing, but the notion of preparing other kinds of professionals around lawyers that can help facilitate the provision of legal services is just now beginning to take root. And this is something that I think we're going to have to watch very carefully. Technology has not had the kind of impact on the continent that one might expect. You have isolated cases, Lagos, Cape Town, Nairobi, but really other than these hub cities, you are not seeing the penetration of legal services or technology impacting the vast majority of folks who live on the continent. Now, what is interesting, of course, is that American law firms are significantly increasing their presence in the continent. You're finding law firms opening branch offices. You're also seeing what we call joint venture law firms, where firms are not merging per se, but creating alliances to provide legal services across a chain of investment opportunities that are flooding into the continent. Now, I think what's striking is that most law students in the continent are studying corporate law. They all want to be transactional lawyers. There are not enough criminal lawyers. There are not enough solo practitioners. In fact, the result is what I refer to as the elitization of legal services. In other words, virtually every student you talk to who wants to go to law school or who's in law school is thinking about working for a major law firm, not thinking about opening up a solo practice or even a regional practice. Most are studying international investment or international arbitration. So again, servicing domestic legal problems, a huge issue. And very few are studying trade law, which is where all of the investment actually is stemming from. And so between the numbers, between the lack of curricular reform, the lack of internet penetration, we're seeing, I think, a crisis brewing. And there's a real need, in my view, to restructure both legal education, but also the profession, broadly speaking. Now, I think what's interesting about this is that there are very few African countries, sub-Saharan African countries, that you will visit in which the judges in those countries are not being produced by one other African country. So it's either a South African judge or a Nigerian judge. So the vast majority of African countries are not producing enough lawyers to even make it up the judicial pathway. That's a real problem. So talk about cultural kind of education. You're dealing with a continent in which, let me just back up a little bit. I have a cultural guru in many of my copyright classes because I'm finding it very difficult to keep up with the millennials and what's happening in pop culture. So every copyright class I have, I appoint a cultural guru who tells me what the latest bands are, they tell me what bling bling means, all sorts of things, right? And I've started in my interaction with lawyers on the continent to talk about how do you prepare judges in one sub-Saharan African country to become a judge in another Saharan country. Right? Now, you've got to remember you have a continent that is divided by three fairly significant legal events, right? So the common law countries dominate. But even within the common law countries, you have countries like Cameroon that are both common law and civil law, that have a history of both French, British, and German colonization. And as you know, the civil law countries are themselves not equal. So you're talking to a Cameroonian lawyer, and they will tell you, well, I'm British Cameroonian, or I'm French Cameroonian, or I'm German Cameroonian. And so those legal traditions are still fairly rigid. And there's an effort now to begin to overcome those differences by creating courts that are just commercial courts, that are fast-track courts. And so the legal professions in countries that have multiple kind of legal histories the answer is specialized courts. So you're seeing the emergence of specialized courts generating a demand for specialized lawyers as opposed to full-scale practitioners that might service the average person. So I think that there's a crisis brewing, and I, for one, am really concerned about that. And of course, Harvard Law graduates that are returning to the continent are part, I think, of a new generation of lawyers, but there's a lot more that needs to be done.
So I'm going to ask each of our panelists just to reflect a little bit about maybe one or two things they really think legal education ought to do or ought to focus on over, let's call it the short to medium term, you might say in the next 5 years or something like that. But then I hope that all of you will be thinking of questions, because I'm going to then open it up for the audience, because as I say, we have many experts and many interested parties here in the room. So Bill, I'm just going to start with you, and I'm going to go around the room, but I know you've thought a lot about this. And what, if you were giving advice, I mean, you could do it to the new dean at Harvard Law School, or you were giving advice more generally in legal education, what do you think legal education ought to be doing in the next 5 years?
I think building on something that all the panelists have said, but specific for Michele, there's a broader set of skills that lawyers traditionally have not been part of legal education. And if you look at the courses at the very best law schools like Harvard, there's still a focus on the traditional set of skills and the traditional training. And I think that there is a need to basically expand our horizons, both even domestically looking at what Michelle's doing and the skills that are required, but then looking, as Ruth said, cross cultures and cross countries to understand that requires yet a different set of skills. And then we have to basically begin to tailor what happens in the classroom to that. So just to give one example, I think when a lot of students come here, particularly for the JD program, they arrive as people who have been individually quite successful. Some of them have done something in their lives that have caused them to work in the teams that Michele has talked about, but they've been largely individually successful. And the course that David and I teach, one of the things we do is after the first day, they work entirely in teams for the whole rest of the course. They're put together with 4 or 5 other people. In my class, we do it intentionally to put people with different experiences, different expertise, different background. In some cases, people like they will conflict, right? So they can start to learn this broader set of skills. They can start to learn that actually tension and conflict is not necessarily bad, right? If you use it creatively and correctively. And that trying to understand the other person's perspective can make the team stronger. So I think it's recognizing this broader set of skills that somebody here has talked about, recognizing that those skills will have different manifestations in different countries, different cultures, different legal systems. And then to try to take what's going on in the classroom and come up with ways to begin to first get students' attention so they don't think it's just something random you're trying to do. And then try to come up with some way to basically help develop those skills.
John, what about from your perspective? You work with a lot of lawyers, and I guess now, actually, you are a law firm in some way. What do you want to see from legal education in terms of helping the lawyers that you work with at LegalZoom?
Well, if I meld kind of our experience with lawyers and some of the things that I've heard today, and we talk about empathy and cultural sensitivity, and I see the problems that we see in delivering maybe 250,000 consultations between attorney and small business owners and families, is communication, but specifically within that, the ability to listen and comprehend and stay quiet. 2 ears, 1 mouth. It's a good ratio. We did a study. We don't do much family law. But we did a little bit. We were looking at the mediation. How long did it take? Sorry, for the average attorney after they asked their first question to interrupt the client? 28 seconds. 28 seconds. So the law is a credence good. Most of your clients don't understand the law. Now your GC will, right? But most clients don't understand it. So how do you judge the quality of something that you don't understand? Part of that is on the relationship and within the communication. So I think in listening on one side, and the second is having a diversity in communication skills, which means as a leader, I know this person's very competitive, and they like to be on stage. I'll motivate and speak to them quite differently than this person who loves relationships and teams, or this person that just likes to solve a problem that no one else can solve, right? And they're different styles, and we all tend to communicate in a single style. And I think one of the things that I've learned over the years is not to communicate the way I like to communicate, but begin with who am I talking to? My job is to get whatever content I need, right, communicated to that individual. So I need to speak in the language. Like, why would I speak English to someone that doesn't understand English? And I think that is a skill set that helps create a much better understanding between lawyer and client, and between lawyers and other professionals in creating these kind of teams for solutions. And I think that's the biggest thing, where you can have great people delivering wonderful monologues. I don't see that kind of listening and response where the people are really connecting. And I think that's the thing that I miss the most.
Michele, you've already done a lot to try to change things, but you're always trying to think about what more needs to be changed, and not just in a program like Law Without Walls, but you also teach civil procedure at the University of Miami Law School. So think about that context as well.
So it's obvious one of the reasons why John has supported Law Without Walls for so many years, because what he's concerned about is what Law Without Walls is trying to do. I think that the 3 things I'd say that we should be thinking about changing is, number one, just a slight shift. Instead of focusing on trying to train our future lawyers and our current lawyers to be better problem solvers, instead focus on training them to be better problem finders. So Tina Seelig has a couple great books that talk about this, and how the best, and I think it's Albert Einstein has that great quote. He says, if you let me have, a bazillion hours focusing on the problem, I can solve your problem in an instant. And lawyers are off the charts when they do tests on our personalities. We really love complex problem solving. We love it, and we're really good at it. But we're also really low on psychological resilience, which means we're thin-skinned. We are very, very skeptical, and if you don't believe me, then I've got you, because you don't like. Most lawyers don't like being told that we're all this way. And we're very risk averse. And all of that combines so that our first reaction is to jump and solve, speak first. Lawyer leaders are known to actually be worse than other leaders to speak first. And because we don't like to take risks and we're thin-skinned, we like to hear the problem, go off by ourselves and try to solve it, and then bring it back, voila. Well, clients don't want that. Clients want to co-create and collaborate on solutions. And tons of research on innovation is that the reason why we get innovations is not an aha moment. It's one person's reasoning on another person's reasoning on another person's reasoning, and a whole lot more time on problem finding, turning something around and around and around so that we don't solve for the symptom. So that's the first thing. And how do we do that? That's the second thing. Here's the biggest problem. Nobody trained me how to be a professor. Lucky for me, I spent 8 years in marketing getting trained in lots of these behaviors, so maybe I'm not the typical lawyer before I went to law school. But how are we going to train the trainers? Now, some of the law professors that are here at Harvard and at your prior school, Minnesota, and at your school and at Miami, they need to stick with what they're doing. But there's a whole nother group that could probably be adding a lot more to the classroom, bringing more to the traditional classroom to inspire this type of skills training. How can we rethink that through? And I don't know how that's going to be solved, yet it leads to the third thing. Technology. Usually I'm not a big believer in saying technology, you know, I'm always saying, let's find a solution, and obviously technology is going to help us, but it is not the solution. I think that we need to think more about how we can, each institution, each law school, use online tools to interact with our students, to teach our students, but also to collaborate across cultures and across schools. So Law Without Walls is the most multi-country, multidisciplinary, multicultural program I know of. We have more law and business school students and lawyers and non-lawyers from outside the U.S. than in. We've got schools from South Africa, from Canada, from Brazil, from Guatemala, from Canada, from Germany, from Iceland, from Australia, from China, from India. So how do we do that? We use technology. So I think the future of legal education, all schools, including Harvard, are thinking about it. How are we going to use technology so we can get this connection for students with some of you and for students from around the world, and break down some of those hierarchies between law and business, between schools of different rank? One of the things I think the most important learning from most students that come to Law Without Walls is, wow, I had a preconception of somebody that might come from that country or that school, and they really contributed to this team as much as I did. When I came in, I might have thought something differently. And I think that technology can help us do that. So those three things: problem finding, train the trainers, and the third thing, utilizing online technology to break down those walls and hierarchies.
Ruth, I'm interested what you think, both from the perspective of the law schools on the continent and sub-Saharan Africa, but also maybe what you would want us here at Harvard Law School to be doing better, since we're such a part of that ecosystem.
Yeah. I mean, I think one of the things that I've always reflected on my time as a student here and now back on the faculty has been that certainly at Harvard, and I think legal education in general, has always, certainly in the last 10, 15 years, thought of itself as going global. There's a lot to learn from countries in the global south that have always been global. These lawyers in Brazil and lawyers in South and Latin America and India didn't have the freedom to be anything but global lawyers. They learned British law. They practiced British style. The profession was structured around German or British or French legal systems. And so there's a capacity for integration in many of these countries that I think we have not yet really appreciated or tapped into. And that's something that I would certainly like to see change. And in part, that's also because countries that are just recently emerging from trauma or chaos, that are just recently discovering their own sense of national identity, have no choice but to be empathetic. If you look at what's happening in South Africa, you look at what's happening in Brazil, you look at what's even happening in Canada now under Trudeau with Indigenous First Nations, this notion of reconciliation, which we teach only in ADR or in mediation, is a notion that I think we really ought to begin to think about incorporating in our mainstream doctrinal classes. I had a moment of truth in my contracts class recently. We studied a case, and my students were very, very upset about the way the judge had handled the matter. They thought it was unjust. They thought it was unfair. They thought it was an abuse of power. And this was the theme go around the class. And as they were talking, I listened and then said, but you know that you're all speaking from a position of power. And there was a moment of silence in the classroom. And they hadn't thought of themselves as lawyers, even as law students, and particularly as Harvard law students, as already in positions of power. And that sort of oversight about their own position, and I said to them, you will walk into a room and not be aware that you're already operating in a set of assumptions that make it hard for the other party to hear you, to listen to you, to be willing to engage with you. And self-awareness, not in the sense of this is who I am, but in the sense of how you are perceived and the position from which you operate, I think is critical, absolutely critical. And the last thing that I would say is we've got to teach lawyers how to fail. We're really good about talking about success. And we think of success really in one dimension. The judge rules in our favor. A student asked me yesterday, how do you find professional fulfillment as a lawyer? Because he's struggling with, do I stay in law, do I go somewhere else? And I said, what is it about being a lawyer that is most meaningful to you? Because if you find that connection between the values and the outcomes that are really vital to who you are, you will find a way within the law and a kind of practice that allows you to maximize both your analytical talent, but also who you are as a person. And I think we do not emphasize enough to our students that part of being a lawyer is helping our clients and ourselves identify the constraints, the limits, and that the judge not ruling in your favor in a case is really not what failure is. The lack of professional integrity, the lack of preparedness, the lack of professionalism, and in some cases, not communicating with the client the limits of the case and the limits of the law in a case are things that we do not do well enough. And I think we need to begin to think about that for these other skills to actually take on important value in and outside the courtroom. Because you think about being a counselor. How many of us lawyers in the room have had to say to a client, this is not a case that I think you should press for whatever the reason is? How many of us have had to walk away from a client that's insisted on a particular strategy that you felt was not appropriate, was ineffective, was otherwise inconsistent with your own sense of how this particular issue should come forward? I think being more self-questioning, that kind of self-awareness is something that I'd like to see us emphasize in the classroom and in our ethics classes and in the kinds of programs that I think Michele is so importantly stewarding, because it's not that there are transnational problems. People are people everywhere. Lawyers are dealing perhaps in a different scale, different level of complexity, but every country in the world, lawyers are being taught how to solve problems. They're not being taught how to actually be part of the solution.
Raj, I know you thought deeply about the values of legal education, and what would you say?
Well, I think at least when I look at the standpoint of Harvard and institutions here, one of the things I will strongly advocate is that it has to become both the curriculum and the pedagogy and the learning experience should become far more global than what it has ever been. I think there is a tectonic shift that has taken place in the last 2 decades, which has transformed the world of legal education and legal profession, and law schools in this country and in some parts of the developed world have not absorbed it, and so that should be done. Secondly, it's very important, again coming from here, there should be a stronger emphasis on international experiences which actually can shape the learning processes much better than what you do sitting in a classroom. Law schools tend to believe that a lot that happens within the classroom can actually solve the big problems of our society. And coming from where I am, I think it's absolutely critical for us to develop solutions that go beyond the law. There is a natural tendency to believe in the law, and that's what we are as lawyers trained to be. But we need to look at social context lawyering and look at how different social institutions are ultimately going to shape the future of any society, and law becomes a very critical social control mechanism among those many institutions. And a related part of that is, I do believe that we law schools in both in India and in Africa and other parts of the world should promote a greater degree of interdisciplinarity in its curriculum and pedagogy. I have to say that geography and even lack of enough collaborative part among different faculty members in different schools inhibits the possibility of promoting interdisciplinarity, cross-registration of courses and cross-listing of courses, something which we have taken very seriously at Jindal, and I do believe that should be that opportunity should be given for law students so that they can look at law in a much broader sense.
So the floor is open. There's a lot interesting here. Yeah, we'll start, Raj.
Well, incredible panel. The only thing I would say, I think I'm maybe the only former politician in the room. More involved in interrupt quicker than more. We go for 10 to 12 seconds. Just very quickly, I run a legal tech technology company called Bodala. We work with law about world. And we're in the data analytics space, so very fascinating. And I want to throw out a little maybe provocative comment and get the panel's reaction, which is, if the question that David proffered was, what's the future of legal education? Now, having been on the front lines of building a business and leading one that's growing quickly, what if the answer is it's really not salvageable? And let me tell you what I mean by that. That if Alexander Hamilton came back today, he would be aghast at this legal system and legal pedagogy, because I think, John, you were essentially getting at the fact that the majority of this country doesn't speak this language. We are all incumbents here. We're all in this silo. We're all checking boxes. We assume that all the markers of our success are good markers, but we look at a legal system that is completely out of whack. There's very little for poor people. As you know, John, the middle class are scared of lawyers, and then of course on the B2B side, you have obnoxiously priced services on the high-end side. And so legal education has been anything but innovative, if you were to compare to the healthcare system or even the business schools. And so, it's actually the legal pedagogy. You have 204 law schools, all of them aiming to be one law school, right? Literally the Langdonian method, which is sort of anti-innovation in its core. So, provocative statement here, but if I'm thinking about the future of the law, I don't even think of law schools as a place where I would spend time, because I think the market is actually making and transforming an industry, and I think that legal education is sort of to the side.
I agree, at least in part, with what you're saying. For me, the future law school should be very different. My vision is one that's a blended program, where you meet in person for a couple weeks and then you go virtual, and that what we're trying to do is train what you might call law consultants as opposed to lawyers. And that doesn't mean that there won't still be schools that will train for the traditional lawyers. But if you think about what technology can do for a school like Harvard, how many more students you could actually train, and you think of 200 law schools who are all trying to be like, I know you're Harvard, there's room out there for a different type of legal law consulting training, and those people will get real jobs and do really great things, but they need to be trained differently. Not everybody needs to be trained to be the corporate lawyer that's going to go out and work at a really huge firm and make a ton of money. There's a whole vast area that actually ties right into John's mismatch, and I think there's a future there. So if anybody wants to help me build that new law school, let me know.
Sorry.
I would just say two things to add to what Michele has said. The first is to complicate your problem even more. Because while technology has, when I started practicing, there were no computers, there was no voicemail, there was no email, there was no Federal Express. And while technology has outpaced, the technology and the business communities and global communities have outpaced the legal system, there is an anchor in the legal system, which is a drag, which is the manner in which we resolve disputes. The judicial system is still largely an 18th century judicial system. And it moves at the pace of a 19th century judicial system. In the case, the iPhone was introduced 10 years ago, and we're still retrying the case. The judicial system actually is a big, I call it an anchor, not in a positive way. It's, as you try to make progress, you're dragging along something that is moving just a lot more slowly. I have a very good friend who's a Court of Appeals judge, and we were talking about how many emails you get during the course of the day. And so I said to him, he's a chief judge of an important Court of Appeals. I said, how many do you get? He said, 6. Right? And 2 of them are usually from my children. It is, that complicates the problem, I think, even more. I said this to David, I mean, I don't know if this is the right prediction, but I could see 25 years from now that there may be only 10 law schools that are 3-year law schools. And the third year is entirely clinical, nationally, domestically, and internationally. That could be very good for the 10. I think it's Harvard will be one of them. I think it's a negative because it's going to be whoever has money enough to support that third year. But you could see something that had 10 law schools that were 3-year programs and a whole set of different law schools that were 2-year programs with internships, not even 2 years, that we're going to come up with legal counsels you're talking about. But we could be well on a path towards that. But then we have these anchors. And in the United States, it includes both the judicial system and includes the ABA, quite honestly.
That's right. Well, it's a regulatory system. I mean, my own view, and then I want other questions, is, we need both more and less. I mean, the idea that there's one model for everything is crazy. And some things people need 6-month certificate programs for. And some things, like double backflip mergers like Bill does, they probably need a degree in economics or business or something else to go along with it, right? So the whole problem is a single regulatory structure and a single educational structure for a very complex, very diverse model. And if that's true in the United States, it's multiplied if we think about around the...
But there's something much, Dave,
Yeah,
quick
please,
comment.
go ahead.
I just want to say that there's something much, I think your expectation for what law schools should be doing may just be misplaced. I think there is a deeper recognition of the fact that law schools and the study of law could also be conscience keepers of a nation. I think some of the more fundamental values of freedom and liberties ought to be protected through our ability to advance the cause of the rule of law. And that's the role that law schools are playing. It's not just about creating an opportunity for businesses and providing legal frameworks for implementing contracts. While that's an important thing, there is something much more deeper and fundamental that the law schools ought to be engaged in. Law schools are the only type of institution suited to do that. And that's why your expectations as to what you get out of law schools ought to be different from many other professional forums and organizations.
So this is what I said at the beginning. There are multiple goals. Jamie.
Yeah, well, just to piggyback on what you said, Dave. So I teach legal profession, and Dave was my legal profession professor.
But she's gone on to excel, notwithstanding that fact.
So in teaching to law students, and it's very important to me, I'm also a practitioner by training, so I come to academia from a slightly different perspective. But this idea of the unauthorized practice of law, right, which David mentioned and which is getting a lot of press these days, how do, and directed specifically to Michele and to John, if you're trying to make things interdisciplinary and feed into the regulatory system, how do we give law students comfort that if they go and they form these partnerships and collaborate, they're not going to find themselves before the disciplinary board in their local jurisdiction, referred by one of these judges who's anchored, in the 18th or 19th century? How do we give students that comfort that they can fail without being brought up on disciplinary charges?
So I'm going to ask John first because they've probably been after his head more than any other human being.
He probably wants
in
the
world.
answer more than
Yeah,
anybody.
that's right.
Well, I guess we have a long and well-documented history around UPL. And it's interesting. We spent $16 million over 11 years on 26 different instances and prevailed in all and continue to do business as we always have. I now spend 5% of what we used to spend 3-4 years ago. So it's almost nil on a relative level. And while we fought through this thicket of UPL, and a part of the problems of UPL is not defined. It's kind of like defined as pornography. I know it when I see it. What's the difference between art and pornography? I know it when I see it. What is the practice of law? Whatever a lawyer does.
Right.
So, sometimes it's very specific. This is not the practice of law, which is helpful, right? Guardrails of what you can't do. And I think greater specificity on a state-by-state level would be better than these amorphous, come to me every time you think of something and I'll tell you what I think. Mm-hmm. But what actually happens is I won't tell you what I think. Do it, and then I'll tell you, which is kind of a weird. That actually has created a 99% fail rate in legal tech. So we're looking for companies to buy. We studied there are 500 that were angel or venture-backed legal tech companies from 4 years before. I paid a banker $500,000 to talk to everyone, get their financials, see who would be interested, potential acquisition. It represents probably $500 million to $1 billion of investment. 0 had 10 million in revenue 4 years later. So there's a massive fail rate, and people are scared. And when we fought through it, now it doesn't really apply. I mean, I think the number one expert is our outside counsel. That's very closely by our GC, very closely by our VP of litigation, because we've probably been in front of everyone more than anyone else. And it no longer really restricts us in any which way. We've clarified and we're on the other side of it. But I see that thicket that we opened and hacked our way through, closed right behind. And everyone trying to do something is getting hit by it again. And where I thought that would have, we actually want more people trying. I mean, when you're mission driven, more people creating access law is better.
That's right.
Right? So we don't think of like, are they competitors? Like, no, they're providing access. That's great. A nonprofit is go, wow, you helped a bunch of people in need. Wow, you're competing with me. We're like, thank you, we need more, right? We're outnumbered, so we need more people. So I think part of it is actually, especially a lot of the thought leaders that are going to be shaping that, is creating better constructs, creating more national constructs. Actually, our biggest ally in everything is the judiciary. There are various Supreme Court cases that actually shut things down for us and clarify. And some of the deans of law schools and others wrote amicus briefs alongside of us, and they prevailed. And that actually helped end a lot of stuff that was out there. But when people are looking at UPL, honestly, the only things that people go after, they never go after lawyers practicing law. They never look at lawyer-driven things. Not until you're big and advertise on TV, they really come after you. And it's an anti-competitive thing, and a self-regulated guild. And I see actually much less of it. I hope to see much less of it going forward. But for the stuff that really makes a difference, unfortunately, that's one of the taxes. We live in a world of regulations and precedents, and innovation tends to be at odds with that. And UPL tends to be a massive inhibitor of activity. And we've got to fight our way through it. And we had to fight our way through it with money. That not everyone has that luxury. Sometimes you just have to fight your way through it because you're doing the right thing.
I think, look, what we've heard here is that we live in a world of tremendous changes happening all around us. And it should not be surprising that these changes are affecting law. As I often say, law and lawyers are a lagging, not a leading indicator of change. Meaning we follow the broader changes in society, like globalization, like technology, like the blurring of boundaries of traditional, kinds of organization or different ways in which we think about the world. And all that is happening in law. And on the last point, regulation has never been able actually to hold these things back. And we see it all the time. It's fraying because there's pressure from the global regulators. So the WTO, we might get gaps in services that requires more openness across boundaries. We see what's happening in the UK. But we see that, roughly speaking, regulation can it can never hold back the dike of change. The real question is, how are we in law schools, and those of us who care about law schools, going to respond to this? And that's something every single person in this room can and should play a role. I mean, by coming back here, for those of you who are alums, by coming back here to engage with Harvard Law School, a place that you care about, you ought to continue to do that, and not just every 200 years. You ought to be interested in what we're doing here on these issues, and you should make your voices heard. And that's not just in this law school, but almost everybody here is connected either to law schools in the jurisdictions where you live, or not just law schools, but other educational institutions that are going to help shape the way in which, not just that we prepare people, I think, as Raj said, but also for what people think about what our legal system is, what its goals are, what its purposes are, and what's the relationship between law and the broader goals of society, like development around the world, like human flourishing. like a sense of dignity, of being listened to, like the idea of feeling yourself as a creative person. I think the biggest challenge that actually it's interesting nobody raised is that in many places around the world, applications to what we now call law school are declining. They certainly are dramatically here in this country. And there are issues in other parts of the world around this set of issues. And it's partly because that faith we used to have in what it was we were doing and its connection to these broader goals of society and public purpose and human flourishing are being questioned precisely because the world is changing. It's our responsibility to try to think through what not the answers are, but what are some ways in which we can grapple and think about those questions in a productive and inspiring way. And I hope that you feel, as I do, that by spending this hour and a half with these 5 amazing leaders, that we have some ammunition for the fight. Thank you all very much.